Look out! It's Tony Law! We best get going! Oh, wait. It's just some of them fancy lawyer folk, probably here to tell the tremendous tales of tomfoolery during them tyrant trials. You know what they say? If you have the quarantine blues and need an antidote, best thing for you is to hear a lawman's anecdote. So howdy and welcome to your daily fixin' of Reddit. This is your archetypically incorrect host, Cowboy Zach, and today's subreddit is r/TalesFromTheLaw.
Damn it! Looks like regular Zach has to host. Cowboy Zach went and caught tuberculosis, but it's okay. It's 2020, it's not a death sentence this time around. Anyways, this first story's called The Case I Cracked. I've always wanted to be Nancy Drew. I even used to have that tidbit on my dating profile. Once, at work, I basically managed to be her. As with most people in the legal industry, my big wins don't generally have epic stories behind them. My biggest two cases were just about insurance companies dicking us around before they realized we were serious about going to trial, so they should finally make decent offers. In this case, our client owned a gas station franchise. The terms of their franchise allowed them to make a certain amount of improvements to the station, which corporate would pay for. It was actually a loan, but the loan would be forgiven if the franchisees continued to buy gasoline from the corporation for a certain number of years. I don't remember how long, it's not important to the story. Basically, our clients would pay the contractor, submit the work orders, and corporate would reimburse them. Our clients hired the lowest bidder, generally not a good idea, but whatever, in a contract that specifically said no contingencies. For those who are not familiar with construction contract law, most contracts give a 10% contingency rate, which means that the contractors give you the rate that they think it will cost, and then they get 10% wiggle room without having to submit a change order. A change order is a change to the contract that the contractor submits to the owner. In our jurisdiction, if the owner did not respond within 30 days, it was deemed accepted, although that is also not relevant in this case. Our clients came to us because they'd been sued by their contractor for unpaid amounts. The contractor had placed a mechanic's lien on the property. This was especially concerning because they had taken out a loan to buy the property and the bank was threatening foreclosure. Our clients claimed they'd paid everything due and more. We counterclaimed by saying we'd overpaid by about $10,000. Because this case involved a land title, it was under our jurisdiction entitled to an expedited trial. The paralegal before me had left for a better job, so I inherited the case about 5 or 6 months before the trial and towards the end of discovery. There were a number of irregularities on the plaintiff's side. The subcontractors had gone over budget. That's not terribly unusual and why there is usually a contingency in contracts. However, our clients had allegedly submitted change orders to corporate to account for that with 10% contingencies. Even with my untrained eye, I could tell that the signature on them was a close but no cigar forgery of one of our client's signatures. For added hilarity, our handwriting expert told me during a break from trial that the plaintiff had originally tried to hire her on this case before my boss approached her to prove it was a real signature. Oops! Since the change orders had contingencies and the original contract didn't, my bosses knew there was some fishy accounting going on. They believed that the contractor was getting kickbacks from the subs or inflating their costs. We subpoenaed the bank records. Generally, I tried to be very specific in my discovery requests, especially if I believe there will be an objection. But I suggested to my boss that I should just request all bank records since the start of the contract and let them object as overbroad. We could always narrow from there. To our surprise, there was no objection. As a side note, I always thought plaintiff's counsel was borderline incompetent. He always typed post-it notes, which annoyed me for no reason. About 2 years later, a giant scandal was unearthed, which, among other things, involved lawyers, judges, and HOAs. He was part of it and was one of the many who ended up committing suicide instead of facing trial. In hindsight, he probably wasn't doing a great job on this case because he had other concerns. Finally, we got the records. At this point, we're 6 weeks or so outside of trial. We got all canceled checks and all transactions for the requested period. It was later in the workday when I got them, and I looked for any kickback-type transactions. There were none. However, when I was flipping through the records, something struck me as off. I couldn't quite put my finger on what it was, but my subconscious knew something wasn't adding up. The accounting that I did was showing our client had overpaid by maybe $1,000, which was not great for our counterclaim, but was a good defense. That night, I did some off-my-payroll work. We were very close to the trial stack, and I hadn't yet come to my senses that I was being paid $10 an hour without any real overtime to do heavy lifting like this. I at least had the foresight to do this in the comfort of my own home. The first thing I had noticed at work was that the contractor didn't really seem to be making a profit. The account tended to hover at the same amount, maybe $2,000. I can't remember the exact amount. At work, I had gone through and cross-checked the amounts the plaintiff had received, paid, and submitted. I'd highlighted them in different colors, and at home, I started entering them into a spreadsheet. As I said before, our clients had slightly overpaid, but not to the amount they believed. When I was looking through the canceled checks, I noticed there was a $5,000 check to someone who was not related to the case with a memo line stating, "Gift." I thought that was super weird. I also noticed what had been bugging me at the office. Every day or two, there was a charge of around $7 at a gas station or smoke shop, about the price of a pack of cigarettes. I realized that the plaintiff had committed the mortal sin of LLCs. He'd commingled funds. I broke out another highlighter and marked all the suspicious transactions. I entered them into Excel, and it turns out that the small amounts regularly over about 2 years is a significant deficit. I presented my findings to the attorneys, and they asked me to pretty it up a bit because their theory of the case had just changed. It was no longer about an evil contractor double charging, but a poor guy with terrible money skills trying to cover it up. Trial soon came thereafter, with many headaches on my part. None of this is relevant to the story, but it's relevant to me. The week before trial, I had been informed that my grandmother was not doing well and was expected to die within the month. The day before trial, my grandfather passed away very unexpectedly. The opposing attorney refused to help with exhibits and referred us to his paralegal, who almost always worked from home. I don't blame her, and his office was unwilling to give out her phone number or email, so I had to contact them and leave a message for her. For the record, she herself was lovely and gave me her contact info. And when we met in person at the trial, was extremely effusive in her thanks and thought the evidence binders I put together were great, which is good because I had to come in early to fix them because the copying service hadn't put tabs on them. At any rate, it was a longish trial for a breach of contract. The owner, head attorney, told us that she had asked for $10,000 in closing. A number of us had been there for various parts of the trial, but not the whole thing, and none of us had been there for closing. After a couple of hours of deliberation, she texted us that we had prevailed with a reward of $44,000 plus punitive damages. We assumed it was a typo for either $4,000 or $14,000, but she meant $44,000. Upon polling the jury, they thought the plaintiff was committing fraud to cover up his personal financial problems. Okay, whoa, they wanted $10,000, but they ended up getting $44,000 plus punitive damages? So these people probably ended up paying like upwards of $50,000 to $60,000, because if they're gonna be willing to tack on punitive damages, they probably took the whole concept of it being a fraud case pretty seriously. So it's not just gonna be a couple grand. Alright, this story's called Broward County Judges Slam Attorneys Over Zoom Appearances. Thought some of you would get a laugh out of this one. One comment that needs sharing, and that is, the judges would appreciate if the lawyers and their clients keep in mind these Zoom hearings are just that, hearings. They are not casual phone conversations. It is remarkable how many attorneys appear inappropriately on camera. We've seen many lawyers in casual shirts and blouses with no concern for ill grooming.
in bedrooms with the master bed in the background, etc. One male lawyer appeared shirtless, and one female attorney appeared still in bed under the covers. And putting on a beach cover-up won't cover up the fact that you're poolside in a bathing suit. So please, if you don't mind, let's treat court hearings as court hearings, whether Zooming or not.
And then here's the full letter. Brovid-19, a message from Broward County judges.
First of all, speaking on behalf of the 90 judges in this jurisdiction, we hope to find you in good health, safekeeping, and not in financial distress. Without revealing anyone else's medical information, the spouse of one of our own is fighting Brovid-19, and we hope for good results. Clearly, the pandemic is no longer just knocking on the door. Of all the divisions in the courthouse deeply affected by the shutdown, family court has been the least affected because it had two aspects unique to it. First, it's a very high priority because of families in crisis and children in harm's way, and second, it doesn't involve jury trials. So, those of us in family have been running dockets, conducting both evidentiary and non-evidentiary hearings, and even trials. And we continue to do so. The criminal courts arguably have suffered the most disruptive impact for two reasons. First, it's extremely rare that any trial proceeds non-jury, and second, the clients have a constitutional right to be present for hearings. While Zoom can facilitate even final divorces, it is not logistically friendly to the demands of the criminal justice system. Now, the positive testing of some inmates in the jail system complicates matters even further. Time will tell when those courts can return to functionality. The civil courts have finally gotten the green light to begin using Zoom to run dockets and conduct hearings. They'll go to school on the lessons learned by the family judges and hope for a very smooth track ahead. Finally, evidentiary hearings via Zoom take additional pre-hearing prep work. For instance, send whatever exhibits you intend to introduce into evidence to both the court and to opposing counsel well in advance of the hearing. Uploading to supporting documents in the e-portal is optimal, email is secondary. And that includes documents, photos, and videos. You'll also have to coordinate third-party witnesses if they can't be on camera. They can't be sworn in by the judge and will need a notary at their location to verify identification and oath. Be aware, Zoom hearings take more time than in-person hearings due to lag time and audio capacity, coming online and people talking over each other, which challenges the responsibility to make contemporaneous objections. Often, lawyers are not looking at their screens but down at their files, their outlines and notes, or simply out the window and cannot see the judge is hollering, "Stop, stop," because an objection has been made and the audio stays with the witness rather than obeying the judge. If you need additional guidance, call the JA and ask ahead of time. Just don't say I told you to. If all this sounds like a challenge, it is, but there is no such thing as an objection to Zoom. That having been said, I for one will not conduct a 2-week expert-laden, hotly contested trial via Zoom. I will reschedule that one for late summer or early fall, if we're lucky. At the end of the day, we conduct these hearings as best we can, knowing we're running on one of those miniature spare tires we pulled from the trunk rather than a real tire. But it will take us to where we need to go if we decrease our speed and increase our caution and shorten our trip. Resolve as many issues as you can through negotiation and then buckle up. We'll get there, but it may get a little bumpy on the way. Please stay safe and healthy and lucrative. Judge Dennis Bailey.
Okay, that was a good little letter. That was a real letter by a real judge, Judge Dennis Bailey. Also, I'm sorry that my judge voice or attempt at a weird judge voice turned into a weird half-baked Hank Hill impression. But that was not my Hank Hill, okay? I can do a pretty decent Hank Hill, but I'm not gonna do it because if it isn't that good, like I think it is, everyone's gonna call me out on it for being bad at doing a Hank Hill voice, and I'm gonna cry. I'm just joking, obviously. I'm not gonna cry over someone making fun of a bad impression. I'll just retire. But also, let me say, keep up the good work, Judge Dennis Bailey. And you too, Judge Joe Brown. I love you. Judge Joe Brown! Also, Judge Judy with that dump truck! This story's called Man's Got Hoes in Different Time Zones. Used to work in a small personal injury law firm. My job was dealing with people's cars and insurance companies, getting their damaged belongings reimbursed, getting adverse driver's insurance comps to accept liability, arranging for cars to get repaired, etc. We had a client once who got in a really bad accident. He was rear-ended on the freeway and the passenger, a female coworker, died, while he got a really bad head injury that required extensive surgery. Important thing to remember, the client and his coworker are both from mainland China and aren't American citizens. I think they were here on a green card or a student visa. His mom is my main point of contact because the client was pretty much out of it due to his injuries. We had the signed power of attorney form. His mom calls me one day and asks how they might go about retrieving their son's belongings from his car, because it was all taken to the tow yard and they haven't had a chance to get it. Like his textbooks, laptop, passport, all his important stuff is supposedly in his car. I give her the tow yard's info and tell her to bring any form of her son's ID that she can, and a copy of his auto insurance card, and I'd give the yard a call in the meantime to explain the situation, since they normally don't release anything to people whose names aren't on the title or insurance card. She gives me a call back a while later and says that the tow yard told her that some lady had already come to pick up her son's belongings. She has a name but doesn't know who this woman is. She also got a phone number, I forget how, but when she called the number, the woman who answered claimed she had no idea who her son was and had no idea what she, the mom, was going on about. I gave the yard a call and they wouldn't give a name, but they confirmed that the woman produced a valid driver's license and her name matched the one on the insurance card. I called the insurance company and they confirmed that the woman was indeed on the policy, and the adjuster confirmed that they wouldn't add a rando or just some friend onto the same policy as the client. So they must have had some kind of formal relationship. I tried calling the number myself, but it's been disconnected. Weird. At this point, I'm figuring that the client had some kind of secret girlfriend that he didn't want his mom to know about. Because how else would some random woman know that this guy got in an accident, know where his car is, produce the appropriate documentation, and take all his valuables? So I get his friend, who was helping the family and knew what was going on, to give the phone to the client while his mom was out of the room. He was awake and lucid at this point, so I can try to figure it out. No dice. He's insisting that he has no idea who this woman was either. His friend tells me that he thinks the client might still be fairly out of it, since he just woke up and was having memory issues. Okay. I tell his mom that they might need to file a police report because I was hitting dead ends. She understood. A while later, we get his medical records from the hospital, and a coworker who was reviewing them told me to go look at them because she thought there was something in there that might shed some light on the mystery woman situation. Turns out, the deceased coworker's husband had come storming into the hospital, blaming the client for his wife's death. Which, understandable, the man was clearly grieving over the death of his wife. But the mother had apparently reported that the husband had gotten the client's landlord to open up his, the client's, apartment and had ransacked it looking for his wife's belongings. Why would a guy be looking for his wife's stuff in another guy's apartment unless he already had reasonable cause to believe her stuff was at his place? The plot thickens. Also, this guy was apparently married to his wife for citizenship purposes, which isn't that weird, but it just added another layer of scandal to the story. But wait, there's more! The hospital also noted that the client's girlfriend flew in from China to visit him in the hospital. At first, I'm thinking, oh wait, is this the girl? That's weird. She lives in China. Why would she be on an American auto policy? As it turned out, her name did not match the name of the mystery woman's. The plot is now thicker than pitch. We never did find the missing items or figure out who the mystery woman was, but general consensus was that this guy had at least 3 different girls going on at the same time. One of them married and one of them living in an entirely different country. Okay guys, cheating is bad, it's horrible, one of the worst things you could do to a person. However, when you remove the personal element of cheating, it can be kind of funny. As you can see here, also, it sucks that that woman died. It wasn't even their fault. Obviously, it's very sad when anyone dies in a car crash or however, but like when a passenger dies who literally was not even in control of the vehicle, that's really sad. Also, this part's only partially relevant to you. It would be more relevant, but I was talking about why this Tesla Cybertruck is really cool, because you've got all this really tough steel all around you. Okay, so now you have some context, but in the case of a really bad accident, you actually kind of want your car to crumble a little bit, because what kills you is the sudden stop. Because what kills you isn't necessarily the impact itself, but it's the time to stop. So when your car crumples up completely, it acts as a little bit of a cushion. So your body and your insides have some time to slow down to a complete stop, as opposed to just turning into soup. Don't forget to like, subscribe, and hit that bell to never miss an episode.